So what is the legal process you face when you get a stunt driving or a racing charge? And a good question is, what should I expect when I'm going to court for my stunt driving or racing charge? The most important thing to remember with any charge, whether you've been charged with stunt driving or racing, is that you are presumed innocent. It's the government's job to prove that you are guilty. You do not need to prove you are innocent. So to prove the charges against you, the government must go through a very specific legal process, and this legal process starts with what is called a first appearance. So how long does it take for my stunt driving or racing charge to proceed against me in the courts? It's a good question, and the charges against you, they're going to take time. The legal process does not happen overnight. However, the courts cannot take forever to prosecute the case against you. Generally, the courts have up to 18 months to bring the charges against you to trial. If your case goes beyond that, the 18-month time period, it may be possible to get your charges withdrawn because your right to have your case heard within a reasonable period of time has been breached. And this is a constitutional argument that you should speak to your lawyer about. So what are the key court appearances that I will face during this legal process? As your case proceeds through the court system in Ontario, you will face a series of court dates that include your first appearance. And again, this is the first time you appear before the court. It is not a trial. You can read more about your first appearance above in one of the earlier chapters. Next, to be spoken to or a set date appearance. The case against you will take time. So for example, your lawyer needs to get all the evidence, prepare a defense, etc. The same is true of the prosecutor prosecuting the case against you. They need time to prepare the case against you, respond to your lawyer, etc. The courts require updates to the process to ensure that the process is moving forward. And these court updates are heard in court, and these court dates are called to be spoken to or set appearance court dates. Another one is a judicial pretrial. In some cases, you may have a formal court date called a judicial pretrial, and this court date is effectively a resolution meeting between you and the prosecutor. If a lawyer represents you, then the meeting will happen between the prosecutor and your lawyer. At this meeting, the issues surrounding your case will be discussed. Potential case resolutions will also be discussed. And finally, we get to a trial. A trial is where the charges against you will be heard in a courtroom in front of a justice of the peace. And that leads us to sentencing. If you are found guilty or enter a guilty plea, generally the Justice of Peace will immediately decide on the penalty. In some cases, the Justice of Peace will decide on the penalty at a future court date. So now it's important to recognize, what is disclosure? Disclosure is all the evidence that the prosecutor will use against you as they try to convict you on your stunt or racing charge. Disclosure includes all the police officers' notes, witness statements, and technical documents, including the notes regarding for example, the radar device used to track your stunt driving. So am I entitled to all the evidence in my case? Absolutely, the answer is yes. And it's important to know the disclosure you get at your first appearance because it may not be complete. And it's critical to get complete disclosure to properly assess your case's strengths and weaknesses to mount an effective defense.